Welcome back to the deep dive. Today we are doing something a little different, something that I know a lot of you have been asking for.
hmm
We are rolling up our sleeves and walking straight into, well, the belly of the beast.
We are.
If you are currently studying for your real estate exams, specifically the Ontario licensing courses, you know exactly what I'm talking
Oh,
about.
yeah. Course 3.
We are tackling the Course 3 module on condominiums and new construction.
It is the section that keeps a lot of students up at night. And for good reason.
It really is. I've spoken to so many people who just, you know, breeze through the residential resale stuff, buying and selling regular houses, and then they hit this wall.
At the total wall.
It's so dense, it's incredibly legalistic, and frankly, it can feel like a minefield where common sense just goes to die.
That's a perfect way to put it.
But we have a mission today. We are taking a stack of source material, essentially a cheat sheet, of the absolute most essential concepts from the course, and we are going to crack the code.
Yeah, we're going to break it down.
We're going to take those tricky PASIC questions and those very dry Course 3 concepts and turn them into a survival guide.
And the goal here isn't just to help you memorize a definition for 10 minutes
Yeah.
so you can pass a test on Tuesday and then forget it by Wednesday.
No.
It's about understanding the logic. Because once you understand the why behind the rules, why the Condominium Act is written the way it is, why Tarion works the way it does, the answers to the exam questions, they stop being a guessing game.
They start becoming obvious. That's what we want. We want those aha moments. We want you to listen to a question and just go, oh, I know why that's a trap.
Mm-hmm.
We are working from a source that distills this down to what we're calling the condo truth package, the money traps and the paperwork nightmares.
And I'm glad we're doing this because this specific area, condos and new construction, is absolutely full of traps.
It really is.
Is the one place in real estate where your intuition will often lead you completely astray.
How so?
Well, in residential resale of, say, a detached home, common sense often prevails. If the roof leaks, you fix it. Simple.
Right?
In condos, you have layers of governance, shared ownership, and specific legal definitions that matter more than anything else. Common sense doesn't always apply.
Okay, so if you're the learner, if you're listening to this to prep for that exam or just to understand how these massive transactions actually work, buckle up. We are going to make the answers obvious.
Let's do it.
Let's start with the big one. Section 1, the condo truth package.
Otherwise known, of course, as the status certificate.
Right. If you've ever bought a condo or thought about it, or even just listened to people complain about buying them, you hear this term constantly. Is the status cert ready? What does the status cert say? But let's unpack it completely. What is a status certificate, really? Is it just like a receipt?
Think of it as a snapshot. It is a moment-in-time picture of the condominium corporation's legal and financial health, but specifically as it relates to the one unit you are looking at.
Okay, so it's not about the whole building in general. It's about Unit 502.
It's about the building as it impacts Unit 502. It is the single most important document in a condo transaction because it tells you what you are actually buying into.
Right. You aren't just buying the drywall and the view.
Exactly. You are buying a share of a corporation. This document is what tells you if that corporation is sinking or swimming.
That's a really important distinction. When I buy a house, I'm buying the land and the bricks, period.
Yep.
When I buy a condo, I'm buying into a business partnership with like 300 of my neighbors.
Exactly. And you need to know if your partners are broke.
You really do. Okay, so let's open up this package. What is actually inside it? When we look at our source material, it lists a few critical things that the exam just loves to test on.
First and foremost, it lists the current common expenses.
Maintenance fees.
We usually call them maintenance fees.
Yeah.
It tells you exactly what that unit is supposed to pay every month. That's the baseline. But then it goes deeper.
Okay.
It looks for arrears.
Arrears. That's just a fancy way of saying unpaid bills.
Precisely. And this is so crucial for a buyer. You need to know if the current owner of that unit, the person selling it to you, is behind on their payments.
Why is that so important? Doesn't that just stay with them?
No, because if they are, that debt doesn't just disappear into the ether. The condo corporation has a line right against the unit.
Wait. So if I buy the unit and the previous guy owes, say, $5,000 in back fees, does that debt stay with him or does it stick to the unit?
It sticks to the unit.
Oh, wow.
If the certificate shows arrears and you close on that property without addressing it, you, the new owner, are now responsible for clearing that lien.
So that's why the lawyer needs this document, is to confirm, Does this specific unit owe money right now?
That's one of the first things they check.
That's a huge red flag if the answer is yes. Okay, what else is in there?
It shows the reserve fund balance. Now, this is the number that everyone fixates on.
Right, the big number.
It is the actual dollar amount currently sitting in the bank account set aside for major repairs. You know, the roof, the windows, the underground garage membrane.
So it tells you how much cash they have on hand. It's like checking your savings account balance before you decide to buy a car.
That's a good analogy. It also includes the budget, the financial statements, and a summary of the insurance policy. And very importantly, it discloses any lawsuits or claims.
Ooh, okay, so if someone slipped in the lobby and is suing the building for $10 million?
It has to be in there. Or if the condo corporation is suing the developer for bad construction, that information has to be disclosed.
Okay, so let's paint a picture here. You get this document. It says the maintenance fees are $500, there are no arrears, and there is, let's say, $1 million in the reserve fund.
Okay.
And no lawsuits. On the surface, it sounds great, right? $1 million is a lot of money.
And that is exactly where the trap springs shut.
This is the adequacy trap. I want to spend some real time here because our source material flags this as a crucial exam insight and, frankly, a career-saving insight.
It is the biggest misconception students, and frankly, even some experienced agents have. The question is, does the status certificate tell you if the building is financially healthy?
Does it?
Does it tell you the reserve fund is adequate?
And the answer is?
A resounding no. Absolutely not. The status certificate gives you numbers.
Just data.
It does not give you opinions. It will tell you there is $1 million in the bank. It will not tell you $1 million is enough to fix the roof that is about to collapse.
That is a massive distinction. I think people assume that because it's this official government-regulated form, it's giving a seal of approval.
It is not a seal of approval. It is a disclosure of data. Think about it this way. If I tell you I have $5,000 in my bank account, is that adequate?
Well, I don't know. Are you trying to buy a sandwich or a brand new car?
Exactly. Without knowing the upcoming expenses, the balance is just a number. It's meaningless without context.
So that condo building with $1 million in the bank.
If the engineering report says they need to replace the entire window system next year for $2 million, that fund is woefully inadequate. But the certificate line item just says $1 million.
So for the exam, this is a very specific trap they set. They're trying to catch the person who equates the existence of money with the sufficiency of money.
They love this one. You will see a multiple choice question where one of the options says something like, the status certificate clearly states that the reserve fund is adequate.
And that's the one to avoid.
That option is almost always wrong. If you see the word adequate attributed to the certificate itself, run away. That is not what the document does.
So who determines adequacy then? How do you even know?
Adequacy is an interpretation. Determining if that money is adequate requires a totally different document called a reserve fund study, which is done by engineers. And it usually requires a professional, like a lawyer, to review it and interpret it. The board of directors uses that study to plan, but the certificate just reports the current state of the bank account.
Okay, so if the document doesn't tell us if it's adequate, and it's full of all this dense financial and legal data, surely it's the real estate salesperson's job to read it and explain it to the buyer, right?
No.
I mean, we're the experts. We're the ones getting the commission.
Absolutely not. And you can hear the alarm bells ringing in the background here.
I can feel you shaking your head through the microphone. This feels like the part where good intentions get you sued.
This connects directly to the salesperson's role section of our source material. The host asks, does the salesperson explain it to the buyer? The answer is a hard no.
A hard no.
A salesperson should not interpret the legal meaning or financial sufficiency of a status certificate.
But wait, we're supposed to be helpful, right? We're guiding them. Why can't we just say, hey, I glanced at it, looked like they have plenty of money, don't worry about it?
Because you are not a lawyer. And you are not a forensic accountant.
Right.
If you look at that document and say, oh, $1 million in the reserve fund, that looks great, don't worry. And 6 months later, the board levies a massive special assessment because $1 million wasn't nearly enough.
You're in trouble.
You have just opened yourself up to massive liability. You gave unauthorized legal advice. You acted outside your scope of expertise.
That makes sense. It's like a general practitioner doctor trying to perform brain surgery. Just because you work in medicine doesn't mean you can do everything.
Exactly. You have a lane, stay in it.
So what is the correct protocol? If we can't interpret it, what do we do? Do we just hand it to them and run away?
You are the connector. Your
Yeah.
job is procedural. It's about process.
Okay.
1, You ensure the buyer actually gets the certificate. Make sure it's ordered, paid for, and delivered.
Check.
2, you ensure the agreement of purchase and sale includes a condition, a specific time period for the buyer and their lawyer to review it.
Right, the review period.
And 3, you encourage, strongly, a third-party professional review, specifically by a lawyer who specializes in condos.
So we are the courier, not the interpreter. We facilitate the transfer of information to the people who are actually qualified to read it.
Precisely. You hand it off. You say, here's the package. Please take this to your lawyer to explain what it means for your financial future. You could point out facts, like here is the page with the budget, but you do not offer an opinion on the quality of that budget.
And for the exam, how does this show up?
You need to watch out for the trap option. It will say something like, the salesperson reviews the certificate and advises the buyer of any concerns.
That sounds proactive.
It sounds like good customer service.
Yeah.
But in the context of the regulations in the exam, it is wrong. It constitutes unauthorized practice of law.
Got it. Okay, let's move to Section 2. We mentioned this briefly, the nightmare scenario. The lawyer reviews the docs, or maybe they don't, and suddenly the condo corporation says, hey, we're out of money.
Enter the special assessment.
This is when the money runs out. Define this for us, because I think people hear assessment and they think taxes.
A special assessment is exactly what it sounds like, but in the condo world. It is an extra charge, a cash call, levied on the owners because the condo corporation needs funds beyond what they are collecting in the regular monthly maintenance fees.
And this is usually because something big and expensive broke, right?
Usually. The reserve fund is supposed to cover major repairs. But if the reserve fund is underfunded, maybe they didn't save enough over the last 10 years because they wanted to keep fees artificially low, and suddenly the parking garage needs a $2 million structural repair.
The money has to come from somewhere.
Right. The condo corporation can't just print money. They can't sell more stock. It has to come from the owners.
And this connects back to the status certificate, doesn't it?
It does. Special assessments fall into 2 categories regarding disclosure. There are those that are already approved, meaning the board has voted and said, we are doing this, it's happening.
So it's a current debt.
It's a current debt. And then there are those that are anticipated. Maybe the engineering report says, you need to fix this next year. And that risk might be mentioned in the status certificate package.
Now, here is the trap regarding how you pay for it. I think most people assume that if you get hit with a special assessment for, let's say, $10,000, you have to write a check for 10 grand tomorrow. That's the scary story everyone tells.
That is the myth. And the exam loves to test this because it tests your understanding of the board's power. The board of directors decides how the assessment is collected. It does not have to be a lump sum.
So they can split it up. They can put you on a payment plan.
Yes. They can say every unit owes $5,000, but we will collect it in monthly installments of $500 over the next 10 months.
Right.
Or they might give the option, pay $5,000 now or pay monthly with interest.
That makes so much more sense. If you demanded a massive lump sum from everyone instantly, you might force people into bankruptcy.
Which hurts the condo anyway.
Right, because then you have units going into power of sale.
Exactly. It's in the corporation's interest to make it payable. So the exam trap here is very specific. If you see an option that says a special assessment must be paid in the lump sum, that is wrong.
It's the must again.
It's the must. It can be a lump sum or our installments. The flexibility is key.
It's interesting how many of these exam questions hang on that word must. It seems like whenever there is an absolute rigidity, it's probably a trap.
That is a very astute observation for real estate exams in general. The law usually allows for different mechanics and procedures. Absolutes are pretty rare.
Okay, let's shift gears to the paperwork itself. Section 3, the paperwork minefield. This is about the agreement of purchase and sale for resale condos. We're stepping out of the financial analysis and into the actual drafting of the offer.
This is where we talk about the don't reinvent the wheel rule.
I love this rule. It basically says, stop trying to be a creative writer when you're filling out a contract, right?
Yes. Real estate agents, especially new ones, sometimes feel the need to prove their value by writing these really complicated custom clauses for the contract.
They think it makes them look smart.
They think, if I write a really long, complex sentence, I look like a high-powered attorney. The exam and industry best practices tell you, stop.
Because the standard forms already cover it.
The standard ORREA forms, the pre-printed clauses, have been vetted by lawyers for decades. They are designed to handle the heavy lifting.
Can you give us an example of something an agent might try to add that is, already in there?
A classic one is the seller's permission to request the status certificate. An agent might write a whole new clause in Schedule A saying, the seller agrees to allow the buyer to request the status certificate and agrees to provide all necessary consent.
Sounds reasonable.
But if you read the fine print of the standard condo resale agreement, the pre-printed text on the main pages, that permission is already baked into the wording.
So by adding it again, you're just doubling up. Or worse.
At best, you are doubling up. At worst, you are creating a contradiction. If your custom clause says slightly different words than the standard clause, you've created ambiguity.
And in law, ambiguity leads to lawsuits.
Yeah, exactly.
And it's the same with approval or consent clauses, right?
Often, yes.
Yeah.
So the exam rule of thumb is this. If you are presented with a scenario where you have to choose between insert a separate custom clause and rely on the clause already covered in the pre-printed wording,
Pick the pre-printed one.
the pre-printed option is almost always the right answer.
It's safer, it's cleaner, and it's less likely to get you sued.
Precisely. Reliance on the standard form shows you understand the form. Writing new clauses shows you probably didn't read the form carefully enough.
Now, sticking with the paperwork, there is a date on these forms that confuses everyone, the requisition date.
Ah, yes. The source of much confusion.
It sounds so ominous. Requisition. It sounds like something from the military. What does this date actually represent? Is it the deadline for absolutely everything?
No, and that is the mistake people make. The requisition date is the title-related deadline.
Okay, unpack that. What does title mean in this context? Because to a layperson, title just means, do I own it?
Title refers to the legal ownership and the history of that ownership. It involves checking that the person selling the house actually owns it,
Okay.
ensuring there are no hidden liens or mortgages that won't be cleared, and verifying that the property description is correct. It's all about the legal cleanness of the transfer.
So it's the lawyer's deadline.
It is the last day the buyer's lawyer can say, hey, we found a problem with the ownership history, and you, the seller, need to fix it before we close.
So it's about the legal right to own the property. Got it.
Correct. But here is the distinction that the exam tests on. It is generally not the deadline for non-title matters.
Like what? What's a non-title matter?
Like a work order from the city saying the fence is too high, or a deficiency notice from the condo corp.
Or just finding out the dishwasher doesn't work.
Right. Those might be handled in completely different clauses with their own timelines.
Yeah.
Or simply under the general home inspection conditions.
So the trap here is thinking the requisition date is a catch-all bucket for every single complaint you might have about the property.
Right. An exam question might say, all title and non-title searches must be completed by the requisition date. That statement is usually wrong.
Because you have to separate title issues from everything else.
Exactly. Title equals legal ownership. Non-title equals physical state or other regulatory issues. And the deadlines might be different. Don't lump them together.
Okay, that is crystal clear. Let's move out of the resale market and into the shiny, optimistic world of new construction.
Yes.
Section 4, the new construction money traps.
New construction is a different animal entirely. The rules change, the risks change, and the protections change. It's like switching from playing checkers to playing 3D chess.
So let's start with Tarion. Tarion is the warranty corporation in Ontario. If I'm buying a new build, I usually think, I'm protected, my deposit is safe, I see the brochures, I see the logo, I feel secure.
And you are, to a degree. But the crucial part is that the limits differ depending on what you are buying.
This is the condo versus freehold distinction.
Exactly. People often hear about deposit protection limits, say $60,000 or $100,000, depending on the price of the home, and they just assume that applies to everything.
But it doesn't.
But for condominiums, the deposit coverage structure is different. Historically, and for certain price brackets, it can be significantly lower than what people assume for freeholds.
Our source material highlights a specific trap where the exam throws out a big number, like $40,000, just to trick you.
Right. If the question involves a specific type of condo unit and asks about the coverage, and one option is a high number that sounds safe, you need to be really careful.
Because it's probably not that high.
You need to know the specific limit for that specific context.
Yeah.
For many condos, the protection covers the deposit up to a limit, say, $20,000, and then there are different rules for any amounts you pay above that.
Okay, so we don't need to memorize the exact dollar table right this second because those numbers can change with legislation.
Right.
But the key takeaway for the concept is, don't assume the protection is infinite and don't assume it's the same as a detached house.
Exactly. The trap is assumption. The reality is there are specific limits, and you need to check the current Contrarian guidelines for the year the purchase agreement is signed. But for the exam logic, be skeptical of any answer that says fully protected.
Now, here's another one that gets people. You go into the sales center, you buy the unit, but then you get excited. You want the granite countertops. You want the upgraded hardwood floors.
The gold-plated faucets.
The gold-plated faucets. You pay extra for these upgrades. You write a check for $20,000 just for upgrades.
The upgrade trap.
Is that money a deposit? Is it protected?
Not always. And this is vital. Not everything you pay to a builder is legally a deposit under the definition that Tarion protects.
So if I pay $10,000 for upgraded cabinets and the builder goes bust?
That money might just be gone. Upgrades are often treated as a contract for goods, a side deal for materials,
Right.
not a deposit on the real property structure. Therefore, they may not fall under the deposit protection warranty.
That is scary. That means if the project gets canceled, I get my deposit back for the unit, but my money for the fancy kitchen is just vaporized.
It is a very real risk, and the exam loves testing this. They will give you a scenario. A buyer pays a $50,000 deposit and $15,000 for upgrades. Then they ask how much is protected.
And you can't just add them together.
If you just add them together and say $65,000 is protected, you will likely get the question wrong. You have to separate the upgrades from the deposit.
Wow. So when in doubt, don't assume every check you write is a protected deposit. You have to read the fine print on that upgrade schedule.
Correct.
Let's talk about the HST rebate. This is another huge topic in new construction.
The harmonized sales tax. Big chunk of change.
Everyone wants that rebate. It's a lot of money from the government. The question is, who gets the check? Does it go to the buyer or does it go to the builder?
And the classic answer in law applies here. It depends.
Of course it does. It depends. Should be the motto of this entire deep dive.
But specifically, it depends entirely on the terms of the agreement of purchase and sale.
Okay, walk us through the two main scenarios.
Scenario A. The buyer paid the full price, including all HST. The builder charges the max. Then, after closing, the buyer applies to the government to get the rebate sent to them personally.
Okay, so the buyer gets the cash later. It's like a reimbursement.
Exactly. But scenario B, which is very common in condo sales, is the assignment.
The assignment.
The builder assigns the rebate to themselves. Basically, they lower the sticker price of the condo by the amount of the rebate, so the buyer pays a lower price up front.
And in exchange.
In exchange, the buyer signs over the rights to the rebate directly to the builder.
So the builder claims it on the buyer's behalf. It's basically priced in.
It's a credit. Exactly.
So the exam trap here is rigidity again.
Yes. If an answer says the HST rebate must be paid to the buyer, it is wrong. If it says it must be credited to the builder, it is also wrong.
Because it could be either.
It can be structured either way.
Yeah.
You have to look for the option that allows for that flexibility.
Is there a risk here? I see the word clawback in our notes. That sounds terrifying.
It's a huge risk. The HST rebate for new housing is meant for people who intend to live in the unit as their primary residence.
Right. It's not for investors.
Or, depending on the specific rebate, rent it out for at least a year. But if the builder credits you the rebate, meaning they already took the money, but then you sell the unit 2 days after closing.
Because I'm a flipper.
Or maybe your life circumstances just changed. Doesn't matter. If you sell it immediately, you have proven you didn't intend to live there. You are no longer eligible for the rebate you received.
And the government wants their money back.
Yes. And since the builder already took the credit, the CRA comes after you, the buyer, for that money plus interest. It's called a clawback.
Ouch. That is a painful, unexpected check to write. You sold the place, maybe made a profit, and then bam, the CRA knocks on your door.
It is. So knowing who gets the rebate and, more importantly, the conditions for keeping it is absolutely essential.
Okay. Moving on to Section 5, the certificate universe. This sounds like a sci-fi movie, but it's really just a lot of acronyms.
Real estate loves acronyms. In the condo world, especially regarding the day-to-day management of the corporation, you're going to see a few new ones that are different from the status certificate.
Let's run through the alphabet soup here. What are we looking for?
You'll see terms like PIC, ICU, and NOIC.
Okay, break them down. What's a PIC?
That's a periodic information certificate. This is sent regularly to the owners, usually twice a year, to keep them updated on basic info, who's on the board, insurance details,
I
budget.
feel like a newsletter.
It's a keep-in-touch document. It ensures owners aren't totally in the dark.
Okay, I see.
That's an information certificate update.
Ugh.
This is sent if there's a significant change between the periodic ones, like if a director resigns or the address for service changes. It's an update trigger.
And NOIC.
New Owner Information Certificate. When a new owner moves in or takes title, this is the form they fill out to get their information registered with the corporation.
The key here, it seems, is differentiating these from the status certificate we talked about earlier, right?
Yes, absolutely. These three PIC, ICU, NOIC are internal management documents for existing owners. The status certificate is the transactional document for buyers.
So the exam trap here seems to be a mix and match game.
They will list 4 similar sounding names. Maybe they will invent one like Annual Condo Status Update Form. You need to be able to spot the fake one and identify the real acronyms.
Got it. PIC, ICU, NOIC. Real things. Super Condo Update Form. Probably fake.
Exactly. Memorize the real ones so the fake ones stand out like a sore thumb.
Okay, last topic in this section. Leasehold condominiums. This confuses a lot of people because the word lease is right there.
It does. A client hears leasehold condo, and they immediately think, oh, so I'm just renting. I'm a tenant.
Right. If it's leasehold, am I just a tenant? Do I have a landlord who can just kick me out?
No. This is a key distinction. You still have ownership-type rights.
This is the hybrid model. Explain how this actually works.
Okay, so imagine a university or hospital owns a massive piece of land. They can't sell the land. Maybe it was gifted to them or they need it for future expansion in 100 years. But they want to build condos on it now to generate revenue.
Okay.
They lease the land to a developer for, say, 99 years. The developer then builds a condo tower on that leased land.
So the dirt is leased, but the building is owned.
You, the buyer, you buy the unit. Yeah. You get a deed. You can sell that unit. You can get a mortgage on that unit. You are the owner of the unit interest.
But the land underneath it all sits on this long-term lease.
Correct. The condo corporation pays rent to the landlord, the university or hospital, and that's factored into your maintenance fees. But crucially, you are not a tenant in the Residential Tenancies Act sense.
You're an owner of a leasehold interest.
Right. You have equity. You have a transferable asset. It's yours.
And the exam trap here would be?
An option stating no ownership rights, just an occupancy agreement, or it's the same as a standard rental.
And those are wrong.
They are wrong. You have an ownership interest that can be bought, sold, and mortgaged. The only catch is that eventually, decades and decades down the road, the lease expires. But for the duration, you are the owner.
This feels like we have covered a massive amount of ground. We've gone from the status cert deep dive to the new construction traps and everything in between.
We have, and if you step back and look at all of it, there's a pattern here.
What's the pattern you're seeing?
The exam is testing your ability to spot absolutes and identify them as false.
Right.
Must be paid in lump sum, false. Must be paid to false is just a rental, false. The reality of real estate law is nuance, and the exam wants to ensure, the exceptions and the flexibilities.
And the other big theme is the boundary of the salesperson.
Yes. That is the one thing to remember. If you take nothing else away from this deep dive today, we are connectors, not lawyers.
Stay in your lane.
We get the documents, like the status certificate, but we do not interpret them. We facilitate the process. We don't act as the judge of the building's financial health.
That's a powerful takeaway. Protect your client by getting them to the right experts, not by trying to be the expert on everything.
Exactly.
I want to leave our listeners with a final thought on this. We talked about the adequacy of reserve funds. It's kind of scary when you think about it, isn't it?
It is.
If a status certificate can't tell you a fund is adequate, and an agent isn't allowed to tell you, the entire financial safety of this massive transaction rests on the quality of that external review.
It does. It forces the learner and the future agent to realize that paperwork isn't just a checklist you go through to get a commission.
It's everything.
It is the only shield against potential financial disaster. When you hand that status certificate to a lawyer, you aren't just passing paper. You are handing over the question, is this building going to bankrupt my client? That is a heavy responsibility, and that is why you need to understand these concepts inside and out.
Deep stuff. But hey, that is why we do this. To the learner listening, you've got this. These traps are solvable once you see the logic behind them. Thanks for listening to The Deep Dive.
Good luck with your studies.